Some Stone, looking at this case from a defense point of view to begin with. You've got a 7-year-old, otherwise healthy, normal little girl. Dies. What, I mean, where do you go with this?
Well, as a defense attorney, in a case like this, you have to embrace the tragedy. I mean, the defense is going to point the finger to some degree at the child and potentially that she took her own life. But you really have to wrap your arms around it. Wrap your arms around the tragedy. This is a poor little girl that did not deserve to die, and you need to tell the jury that right off the bat.
Yeah, the problem with that is the defendant, the mother of this little girl, according to everyone who saw her after her daughter's death, didn't seem particularly sad about it, wasn't shedding any tears. The only emotion she really had was anger that the police were questioning her.
Yeah, and I think that's potentially going to be one of the issues for the prosecution, is showing the inconsistencies of her statements versus what the evidence showed, showing her demeanor. She's got several tape statements that she gave to the police, and certainly that's great facts for the prosecutor. From the defense, at that point, you need to turn and focus on the sloppy investigation. There were some mistakes made in this case from the investigatory standpoint, and you really want to try to turn the focus from the tragedy to the sloppy police work, so you kind of take the focus away from your client a little bit, or certainly the demeanor, which is not boding well for the defense in this matter.
No, you just look at her. I mean, if this is a trial and you're here, because the jury, this is something, Stone, that a jury can relate to. Any juror that has a child, you understand what those emotions are like, how strong they are, and what a devastating tragedy it would be to lose your 7-year-old if it wasn't something that you did yourself.
Well, and the reasonable person would be jumping out of their skin. I mean, as a father myself, I can't even imagine losing a child and then being accused of killing that child. But the defense has another issue that I know was contentious during the trial, and that's the intelligence level of their own client. I mean, she was alleged to have only a 66 IQ, and that's the type of evidence you want to put in front of the jury to kind of diffuse the lack of reaction from your client, that perhaps she's just not all there and just doesn't have the same type of emotional capability that you and I would have. So that's certainly important evidence that you want to be able to bring out to the jury to at least diffuse that other side.
And as we go to a break, we want to update you on today's
the dog. Well, Stone, Grissom, let me bring you back in, because that's really part of the motive in this case, that this mother killed her daughter because the next day the daughter was going to be meeting with prosecutors to talk about the sexual abuse allegations against the son. You know, one of the big problems I see in this case is those allegations came to light in February of 1999, and it's not until September that this little girl is meeting with prosecutors. What's going on?
Well, it's even worse than that, because the evidence that comes out from the defense is that the mom, after hearing about the allegations, immediately takes her daughter to the doctor's office to make sure that she's okay, and then exits or ejects the child in question from her house along with his family. So she does take appropriate, what the defense would say was appropriate and actually expedient action to make sure that the allegations were false and not not substantiated.
Well, Stone, then maybe, and I agree with you, that is
the prosecution's trying to do is attack the credibility of her statements, that these were just fabrications or lies, or certainly, you know, just say that it happened in the past, therefore it happened this time.
Oh, come on, Stone. How does a 2-year-old OD on Benadryl? You know, I know you're a dad, I'm a mom. To get kids to take medicine at all is usually a big challenge. To get them to take one little spoonful, you got to trick them, you got to bribe them, you know, you got to do whatever you do to get them to take the little tiny bit that's prescribed for them. I mean, how does a kid on their own OD on medicine?
Well, and that's the issue here, but she was never charged in those cases, so, or she's never been convicted in those cases, so, you know.
Well, maybe she should have been.
She might have been, but certainly it's overly prejudicial to say, well, it happened when it was 2, therefore she had something to do with that when this child was 2 and a half.
But doesn't it show a pattern? What this woman does when she has a problem with her children is she drugs them.
Well, I think as a defense attorney, you're going to have to stand in front of that jury and say, my client is not the mother of the year. There's certainly bad parenting going on in this house, but that a murder does not necessarily make. These kids may be in a very bad environment, not a great home environment. That maybe she shouldn't be the mom, of these children. There should be some intervention going on. Certainly there has been some degree of intervention with this respite care, but that doesn't equate to murder. And I think the evidence can cut both ways. She lets her child run around the neighborhood unattended. She just says, go out and play. We don't know how well she was trying to wake this child up. Did she just yell at her and say, get up, and the child didn't move? And was she not paying attention? And it'd be reasonable the child could have gone in and played and maybe taken medicine accidentally. I mean, those are the types of issues that you want to be able to put in front of the jury from the defense standpoint, because it doesn't look great from the prosecution side right now.
More disturbing information about
Equivalent of about 90 pills of imipramine in her system. That's an antidepressant. It's also prescribed for bedwetting. 90 pills. So if she did this on her own, it's hard for me to see a 7-year-old taking 90 pills, one right after another, and swallowing them. On the other hand, it's also hard for me to see how her mother could have ground them up in something and given them to her to drink. I would think that's something that you would notice when you drink 90 pills, right?
Well, imipramine actually is dissolvable in water, so it is reasonable to assume that if she were to have crushed up the pills, that they would actually dissolve in the liquid. I don't know if it has a taste or not, but
Yeah, I guess she could put juice in there. She could put some flavoring, right, to cover it up.
yeah, one of the issues that's going to be brought out in the defense is this idea of post-mortem redistribution and where the blood was drawn and where did they do the toxicology, from what part of the body was the blood drawn in which they did the toxicology report. Because when you're taking medication, especially over a long period of time, certain medications are absorbed in your tissues, and when you die, that absorb, they're released, your tissue releases it back into the bloodstream. And if you take blood from an organ, you can get an overly exaggerated amount of whatever the drug is in your system. And that's one of the issues for the defense here, is that they took it from the wrong spot. They took it from an organ instead of from the femoral artery, which would give a more accurate depiction of how much drug of this imipramine she had in her body. So certainly that's going to be an issue for the defense, and I'm sure we're going to hear that in the opening as well.
So, Stone, in a case like this, you think there's a strong expectation by this jury that the defendant herself will take the stand and will tell the jury, look, it's my daughter, my 7-year-old daughter. No, I did not kill her.
I think you spend a long time with the jury in voir dire in a case like this, where you have taped recordings of your own client's statements that if you put her on the stand, she's going to have to deal with that. And the cross-examination is not going to be pretty, because there are some potentially or seemingly inconsistent statements that she makes. She's also not the brightest person in the world. We know her IQ is a little bit less. So you really have to weigh that. I don't think you make the decision before opening.
Do you explain to the jury that your client isn't the brightest?
I think you have to, because they're going to be judging her demeanor the entire time. They're also going to be judging the way she reacted. I mean, we're going to hear testimony in this trial, how she reacted right after her daughter was determined to be dead, how she reacted with police, with investigators. During the taped statements, they're going to hear her demeanor, and we're going to hear from the jailhouse snitches, so to speak, about the way she reacted while she was incarcerated. So I think you have to put that issue out in front of the jury so that they understand the complete picture of your client. And you also have to, again, spend a lot of time in voir dire just in case you don't put her on the stand. That's not helpful.
Well, who's your ideal juror in this case? Because do you want a parent up there? Do you want mothers? Do you want fathers? Do you want people that don't have children?
You don't want mothers. I don't think you want mothers.
I'll second that.
Yeah, I don't think you want mothers on this case. You want to get as many women off the case, especially parents, off the case as possible. I think if you're going to have a parent, you might want to make it a father. And I say that not to say that we're less feeling than the mother, but I think there is that emotional element that you have to at least try to deal with and diffuse to some degree. And I think I see mothers punishing her just by the accusation itself.
Yeah, well, I don't know if I would punish her just for the accusation.
Yeah, no, I agree. I think that there is an issue of a history of child abuse, or at least bad parenting. This is probably not someone who should be raising children. It's not a healthy environment. So you can't run away from that from the defense standpoint. But the evidence that I'm assuming will come out from the defense is that this little girl has made statements in the past about committing suicide, about taking her own life. So she is already a troubled
But see,
child.
I attribute that back to the parents too. You give me a 7-year-old who's suicidal, I'm going going to give you a parent who's abusive.
Absolutely. I mean, the defense walks a fine line with that as well, because you have to somehow demonize your client to some degree, saying she's not a good parent, but at the same time you have to protect her by saying, well, that just because she's a bad parent, shouldn't be a parent, doesn't mean she committed murder.
Yeah, but it's not all that far from it to say that perhaps she drugged her child.
Stone, what do you think of that as part of the opening statement here for the defense? Kind of painting the picture of who this victim is, saying the victim was a hand. Is he trying to justify something, perhaps?
Yeah, he's getting the right information out, but I wouldn't have done this. I mean, that's certainly painting the wrong picture, because you can almost see him strangling, the mom strangling the child. But you know, I think again, what he needed to do is stand up and say, you know, this is my. You may not like my client. My client's challenged. He did say that, but I think you have to embrace that. He did say this case is about Monique. I think you have to really just talk about the tragedy. This is a girl that did not deserve to die at all. There was nothing that she did wrong. Her being a handful is probably because mom was a bad parent. And I think as a defense attorney, you just have to say that. She's not a good parent. She has
You cannot cast any negative aspersions on this.